A warm welcome to all of you to SP Legal Services. So here I like to say about the diverse case filing procedure in this video. I will explain you how it goes and the procedure. See here, the diverse case filing procedure involves preparing a joint petition, filing it with the family court, and attending a first motion hearing after a mandatory cooling off period of at least 6 months. Generally, we are calling as 13B, mutual consent, mutual divorce. Say a second motion is filed and a hearing is held to obtain the final decree of divorce. Key documents needed include a marriage certificate, address and income proofs, and proof of a separation. I also explain in this video steps for filing divorce case. See, step 1 is gather documents and file the petition. Collect the necessary documents, gather all the required documents such as the marriage certificate, address and identity proofs, both spouses, and a recent income tax statement also if it is required. Sometimes draft a joint petition, work with an advocate to draft a joint petition that clearly states the grounds for divorce and outlines the agreed upon terms of for asset division, alimony, and child custody if they have. Even file the petition, submit the drafted petition and all supporting documents to this appropriate family court. This is known as the first motion. This is the first step in a simple way. Later, both the parties attend the first motion and wait for the cooling off period. Generally, some advocates say that in 1 month, I can make you get the divorce certificate or maybe decree or order. It does not happen. It's not possible at all. Wait for the cooling off period. First court appearance compulsory. Both spouses must appear before the court to have their statements recorded. The court may attempt reconciliation. Yes, sometimes court may attempt reconciliation. Cooling off period is after the first motion. The court grants a mandatory cooling off period of 6 months, even to 18 months also, for the couple to reconsider their decision. It's very important. Even later, file the second motion and obtain the final decree. Even I say what is the meaning of second motion. If both parties still wish to proceed, they must file a second motion within the 16 months time or maybe 6 months. Later, final hearing. Attend the final hearing where the court will record the final statements and arguments from both sides. Receive the divorce decree. If the court is satisfied that the divorce is by mutual consent and all matters are settled, it will issue a final decree or divorce. Here, the important factors considerations are mutual versus contested divorce. Both are different. Mutual and contested divorce. The procedure described above is for a mutual consent divorce so far. A contested divorce has a different, more complex process. More complex. Yes. Even we do not know exact time also. We cannot even guess even sometimes in some cases. Even legal consent, it is highly recommended to hire a lawyer to help you with the entire process. Like withdrawal of consent, a spouse can withdraw their consent for a divorce at any point before the final decree is passed. It is very important. A spouse means anybody, wife or husband. A spouse can withdraw their consent for the divorce at any point before the so these all things crucial role to get the divorce, whether mutual or contested. But my advice to the all people, when you want to be separated, always safe, better, advisable is taking divorce from court. I've seen some cases. Some people approach me, sir, can you write something on the bond paper? Your advocate, your signature is powerful, your drafting is powerful. So prepare drafting so that we don't like to come to the court within the office room or maybe before the elders or maybe village elders. We take some witnesses. We should write some agreement, diverse agreement, mutual consent, diverse agreement, so that we can be separated from here only. The alimony, the rules and regulations, agreements, conditions, we can write down on the paper so that my father, her father, we both sign. Not acceptable as per law. One thing I suggest you that there are two ways. You are decided to live separately, unconditionally, better to approach advocate. There are two ways. One is ex parte decree, you can get it. If husband files, if you do not attend the court, ex parte decree, that is also call it as divorce only. Either wife sends a notice from the court, then husband does not attend, it is also ex parte divorce decree. We can get it within 3 to 4 months or 2 months only possible. Otherwise, go to the mutual consent. Very simple process. We both of you can choose only one advocate. He or she makes the drafting, the reason, everything she or he will take care of it. First hearing, you need to appear before the honorable court. They take the oath. They 6 months, but we can make it as 4 or 3 months also. Depends on the urgency. We have to explain to the honorable court why you want advance early. If court satisfies, for example, you or anybody, any spouse, wife or husband, getting any other marriage proposals or any foreign opportunity, any valuable, reasonable reason, if you mention, court can grant decree or divorce decree very early also. But very early means not 10 days or 1 day, 1 month, not possible. Minimum 4 to 6 months. So relevant documents are required: marriage certificate, marriage photos, Aadhaar cards, rental proof. These things are very important, crucial. Right? Thank you very much. If you have any need any information regarding divorce process or family related issues or civil nature issues, anything, please contact our team members, SP Legal Services, Hyderabad, Dilsug Nagar. You can contact through WhatsApp also, 8886222276. Wish you all the best. Thank you very much. Jai Hind.